Section 21, License Law and Commission Rules. Historically, between the national and state sections of the licensing exam, the state section is failed the most. Particularly, more than 60% of candidates do not understand when a firm license is required by law. The standard broker's real estate license only gives individuals the ability to help people buy, sell, or lease real estate. Anytime a broker would like a partnership, a corporation, or a limited liability company to be paid instead of direct payment to the licensee, that entity must have a current North Carolina real estate firm license. In building a business, brokers may hire people who are not licensed to assist in certain real estate transaction activities. The permitted activities vary upon the type of brokerage being performed. If a broker engages an unlicensed assistant in sales, the assistant is limited to clerical type duties. That assistant may legally submit data to the MLS as long as the information was gathered by a licensee. They may do simple administrative tasks such as filing or answering phones. An unlicensed assistant in sales may place lockboxes or signs on properties, and they may schedule appointments on behalf of the broker. However, when dealing in sales, an unlicensed assistant may never solicit business on behalf of the broker. They may never show property. They may never give transaction-specific information, never negotiate any type of contract, and may never be considered or give communication of contract acceptance. Brokers that hire unlicensed assistants in property management may allow their employees to do a little bit more than unlicensed assistants in sales. In property management, unlicensed individuals may help prepare leases. They may accept monies such as rents or security deposits. They may show properties that are available to rent. They may act as bookkeepers, and of course, they may complete basic clerical duties. Just as in sales, there are some duties the unlicensed assistant in property management cannot do. They may never negotiate contracts or leases, and they may never prepare the information that is to be placed in advertisements. On the subject of advertisements, North Carolina licensing laws and commission rules have specifications regarding any ads placed by a licensee. All advertisements must have approval of the licensee's broker in charge, and all advertisements must clearly state the name of the licensee's firm. Advertisements that are unclear as to the fact they were placed by a broker and not the client or principal are known as blind ads and are not permitted by commission rule. Real estate transactions involve a lot of paperwork. Thus, all agents must give copies of any transactional paperwork to all clients or customers within 3 days. Remember, this includes giving copies of paperwork to the supervising broker in charge within 3 days. That is 3 calendar days, not business days. A broker in charge must be involved in any transaction that involves trust monies. To ensure against commingling or the mixing of a broker's personal funds with the funds of others in a trust account, the North Carolina Real Estate Commission allows up to $100 of the broker's own monies to cover any fees charged by the bank. In cases where the fees exceed $100, the needed amount is allowed to be kept in the account.